appeal is the appeal of Nikola Katic against Republic of Croatia.
Yes, Mr. Azzopardi.
My lords, my lady, can I just say at the outset, on my behalf and on behalf of Mr. Rocca, that we're very grateful for the board relisting this matter at short notice after the travel fun that we had last week.
Well, we're all delighted to see you both and full of sympathy for the vicissitudes which you suffered in trying to get here previously. So all's, in that respect, well that ends well.
Oh, grateful. My lord, I appear with Mr. Brunt and Mr. Rocca appears with Ms. Gear. As the board knows, this is an extradition appeal from Gibraltar and involves at its heart the construction and interpretation of a section of the Gibraltar extradition legislation. Now, I am in the board's hands, of course, but I intended to structure my submissions in the following way, but when I finish outlining how I intended to structure it, perhaps the board can give an indication as to whether that is the board's desire. I intended to make some overview points and deal with what are, I think, in our submission, common ground and battleground issues. Then I will deal with the point that was certified of public importance by the Supreme Court in Gibraltar, and the issues in the statement of issues and how we say for the appellant they should be answered. I'll do that in overview. Then I intend to give just a salient sense of the facts, deal with the issue of interpretation, the framework, the Act in Gibraltar, and the case law in support. But as I say, I'm in your lordship's, my lady's hands, if that is not what the board prefer me to do.
No, I'm perfectly content with that, Mr. Pardy. I would just say this, that we've now, perhaps partly because of the relisting of the case, had a very good opportunity to look at the materials, the written submissions and the issues. So if either or both of you find it unnecessary to take the whole of your allocated time,
yes,
we would understand and be very happy with that.
My lord.
But we're not pushing you, and you've got the allocated time if you need it.
Yes, my lord, yes. And equally, I would hope that while that sounds like quite a long outline of the heads that I am going to go under, I would hope that once I get going, it'll be relatively swift through some of that part.
You're going to follow, I think, Sir Maurice Finer's first law of advocacy. You tell him what you're about to say, then you say it, and then you say it again.
My lord, yes. So, my lord, my lady, the common ground issues, if I may, first. It's common ground between us that under Croatian law, Mr. Katic was tried in absentia, and he has the right to a retrial or an appeal. When he goes back, he's got 12 months on surrender. The time will start then. Within 1 year of surrender, he will have the right to file an appeal or seek a retrial. Also common ground that he was a resident of Gibraltar.
Is it common ground that he will have 12 months from the time he goes back? Because I didn't understand that to be the case from some of the submissions, but
I believe it is common ground. My friend will correct me, but I believe it is common ground, and it's we would say it's clear from the face of the arrest warrant that the time will run from then. Yeah. It's common ground that he was a resident, as I say, not common ground as on the time he became a resident. So the appellant would say it's 2015, but it is certainly clear that he was in possession of a Gibraltar identity card issued by the Gibraltar authorities since 2017. So common ground, at least, that he's been there, established some form of life in Gibraltar for the last 5 years. Also common ground that he's been in custody now in total for a period just above 6 years and 7 months. 4 years in Croatia, pending trial. And in Gibraltar, he has been in custody since the time that of his arrest under the EAW. So since December 2019, so 6 years, 7 months. And also common ground that if he was serving his sentence in Gibraltar, in other words, if there had been, say, for example, the execution of the on the condition that he was going to be returned to Gibraltar if a sentence was imposed of the same nature, a 10-year sentence, if he had gone to Croatia, failed in any appeal, or foregone his ability to appeal in Croatia and would have returned to Gibraltar under the return condition, he would be due for automatic release now. That is common ground between the parties.
As I understand it, he wants to exercise his right to a retrial, then.
Well, my lord, the position that he has always taken is that he wants to take Croatian advice on that. Of course, that was the historic position, but as time has gone on, and because we are here now at a time that if he had served that same sentence, he would now be due for automatic release, then his instructions are, which we convey to the court, and I would get to in my submissions, that if the court were to be minded to have consideration to that issue, in other words, the issue that he has now in effect been in custody for as long as he would have had to have been to have served a 10-year sentence under Gibraltar law, and if the court were minded to invoke the provisions of Section 33A of the Act, which allow the court to direct that the person to be extradited should serve his sentence in Gibraltar, that he would be willing to forego any rights of appeal or seeking a retrial in Croatia on the basis that the court, he would consent to the court making an order under Section 33A so that he would serve his sentence in Gibraltar. I hope that answers your Lordship's question. My Lord, it was not common ground on the face of the skeleton arguments, but it is now common ground that because we accept that the interpretation exercise is one of conforming interpretation. I would say that at the outset because there was a disagreement, I suppose, between us, only because we had inserted into the authorities what was the leading authority from the Privy Council on extradition from Gibraltar, which was French and Portugal. French and Portugal applies what was said in the case of Assange, and in other words, that it was not conforming interpretation, it was the common law presumption, but we recognize now, on the basis of our discussions with our learned friends, that Britain did opt in. Indeed, there is a case in the bundle that we put in, which is the case of Zat, I'm going to get this pronunciation badly wrong, no doubt, but Zatkovsky, which is at electronic bundle 836, and that case is a case post the opt-in of the UK, where the Court of Appeal hear an extradition case in the UK, and it proceeds on the basis of conforming interpretation, and we put that into the bundle because we were on the road to accepting that, and we now accept that it is a conforming interpretation exercise. What we say there on that particular issue, that even though it is a conforming interpretation exercise, it does not, however, alter the outcome that we argue for, because on an application of Pupino or the conforming interpretation doctrine, we say that the Gibraltar provisions, in particular Section 8A, conform entirely with the framework decision. So we're going to descend into detail later on that to examine it. My learned friends, I'll say at the outset as well, because this is a battleground issue, I suppose, my learned friends rely on a case called X, which is at electronic bundle 511. I'm going to go to that case, but what we say in overview about that case is that it is irrelevant because it is a case about a different article and a different wording, and when we compare the different wording of Articles 4.6 and Articles 5.3, it is clear that the case of X is of no assistance, and indeed that we would say the construction should be as we contend for. My Lords, the point certified by the Supreme Court below, the issue of general importance, is at electronic bundle 95. And what the court certified was this, that where a person has been convicted and sentenced in a requesting state and has voluntarily absented himself from part of those proceedings and has thereafter acquired residency in the executing state, is the Magistrates Court entitled to order that a European arrest warrant be executed in the absence of an undertaking in accordance with sections 8.2 and 8A3 of the Act? We will say that we will contend that the answer to that question should be no, because the section should be interpreted as a mandatory provision. The second point certified was that if the answer was no, was the judge obligated to allow the appeal? And we will argue that the answer to that question should be yes, because the provisions of the Act, namely in particular sections 38 and 39 of the Act, which are at Electronic Bundle 237, 238, they make clear, when you analyze it, that there would have to have been an order of discharge. That's what we will say on the point of general importance.
At some time in your submissions, it's going to be helpful, I think, bearing in mind that an undertaking has been, I think, delivered at least to the Supreme Court, albeit not, I think, to the Magistrates Court. Yes. It'll be helpful to have your submissions on whether, in fact, that question is one that has to be answered for the purposes of the determination of the appeal. In other words, in a case where an undertaking is supplied but only during an appeal process to the Supreme Court, is that good enough? Don't answer now, but it does seem to us,
yes, well,
I think that's a question that arises on the facts.
I'm happy to address it now, but I'll address it in this way, if I may. I'll start first by just simply saying, perhaps we can address it also later during the submissions, but I'll say first that the judge in the Supreme Court found that the guarantee, for want of a better word, the guarantee had to be submitted at the time that the EAW was delivered. That's clearly in her judgment. I can give you the reference to that, if I may, just very quickly, my lord. That is at it's Electronic Bundle 78. And paragraph 5 of her judgment, she says, at the end of paragraph 5, I am of the view that if a guarantee was required by operation of law and was not received with the EAW, then the EAW would be defective and cannot be cured retrospectively. The only question for this court to determine is therefore whether a guarantee was in fact required. Her finding was that the guarantee had to be received when the EAW was received. Now, what I will say on that is this. First of all, there is no cross-appeal by Croatia on that point, and we say that is relevant. If, however, I were to venture a submission, if I may, on that, even though there is no cross-appeal, if your Lordship is inviting me to express views on it, well, in a nutshell, our views are at paragraph 33 of our skeleton, which is at Electronic Bundle 145, and so the view that we take, not the view that the court below took, the view that we take is that there are two potential readings of that. So it may be that the guarantee can be submitted at any point before the order of surrender. That's our primary submission. Our primary submission is it should be received before the order of surrender. Our secondary submission, which is also at 33, is that it is possible to interpret it on the basis that it does not need to be received before the order of surrender, but it needs to be received before actual surrender, because there is a certain time limit under the statute before the surrender. It needs to be put in as a condition of the order of surrender on the basis that it could be received within that statutory period. If it is not received, then the particular person would be discharged. If it is received, that person could be surrendered. So we say it's capable of those interpretations. We favour the first interpretation. We favour the first interpretation that it has to be before the order of surrender for these reasons.
But just before you on, if that's right, in this case, the appeal court made a fresh order for surrender after I think it received the undertaking. So, I mean, is it your case that that condition, if that's the right approach, is satisfied on the facts? Or do you say there's something wrong with the second order for surrender?
Well, the second order for surrender, my lord, does not have a condition that he should be returned.
No, it doesn't. But the court had by then, I think, received the undertaking, hadn't it?
It had received the undertaking, but has found, and there is no cross appeal, that the undertaking is defective for that reason.
Yes, and it made the order for surrender, obviously, for a different reason. But if we were to conclude that the court's reason was wrong, but nonetheless it had the undertaking before it made the order for surrender, you'll no doubt help us on whether we should allow the appeal and set aside that order for surrender.
Well, so this would be our submission on that. Unfortunately, for that invitation, if I may, what we would say is that the statute does not allow for that conclusion, because the Act towards the end, at Section 44 on the Section 44, 45 say that if an appeal is allowed, the appellant should be discharged. It does not have a statutory power, does not give the court a statutory power to set aside and vary the order when it is a case of an appellant's appeal against his surrender. It does have, the court does have power to vary and remit an order when it is an appeal from the issuing state. If this was an appeal from Croatia, then it would have power, and I'll take your lordships to that later if your lordships wish to see that, or if your lordship wants to see it now, I'm happy to do it now.
Well, you take your course, but I simply raise these so that you, as it were, on notice that these are matters which...
I mean, really, it's just a matter of working out what the proper procedure is, isn't it, where the guarantee's been given. It's not some sort of game, whereas if you don't get it there in time, then he has to be let out, whatever happens afterwards.
Well, my lord, it's not a question of a game. Obviously, there are certain statutory requirements.
Yeah, but if the guarantee's been given, as it has now, why don't we just dismiss the appeal? He's got the guarantee.
Well, my lord, you'd have to, what we would say is that it would have to be on the basis that it should be subject to a return condition, so that if he is surrendered on that basis, it's clear that there was a need for a condition because it was mandatory. The court was in possession of it. The court was wrong. I'm just pulling the thread from your lordship's argument. The court was wrong to hold that it needed to be received at the time of the EAW. The court had it in front of it. It was mandatory, so therefore the court was wrong that it was not mandatory. It should have been a condition, and therefore that is the basis on which the outcome could proceed. But my lord, it would have to be on that basis and no other basis. The conclusion, the ultimate conclusion, might then be the same. In fact, if he is surrendered to Croatia and on that basis, and he then forgoes any rights of appeal, he would then come back to Gibraltar on the basis that he has served his sentence. That would be our view of it, if that is what a possible.
When you say he'd be entitled to be released, is he just released completely, or is he released on licence, so that the remainder of the sentence might be triggered if he commits another criminal offence? What is the position as to...
Unlicensed. Yes, yes, it's on licence.
Yeah.
It's on.
No, there seems to be a difference.
Surely he would be discharged.
No, it's just that if it may be relevant, the undertaking may still be relevant if the point is that, yes, he may be released, but if it was here, he would be released on licence, and then if he was convicted of some other crime, then the remainder of this sentence could be reinstated, and then there would be a question as to where he was going to serve the remainder of that sentence. So if there is, I don't know whether there is a licence regime
There is a licence regime, lady, in Gibraltar.
I think your opponent is anxious. Yes.
If I can assist, my lords, there is a licence regime after 1/3 of the sentence. After 2/3 of the sentence, the sentence is complete and release is absolute. So the licence provision applies after 1/3.
But we're in 2/3 country.
Correct.
Right.
I'm grateful to my own friend. Of course, I defer to the Director of Public Prosecutions on this one. I don't appear as frequently in the criminal courts as he does.
So 9 years, in fact, means 6 years completely in Gibraltar.
Correct.
Not even the nominal continuation of the sentence.
At the time of this sentence, it's actually 50% nowadays. It changed a couple of years ago.
Right.
Can I just ask, do you accept that, particularly, for instance, in prison cases, that it is quite common for undertakings to be provided on appeal hearings and taken into account by the court in determining whether or not to allow or not allow appeals?
In terms of this specific undertaking?
In terms of seeking undertakings from...
I think my Lord has prison conditions, for example, if the sort of conditions that you'll be held in the state to which you're returned. It's quite common, at least in this country, for undertakings to be required on appeal. You have to sell a certain size or something.
My Lord, appeals on these matters in Gibraltar are rare. I am not aware of any authority in Gibraltar on which the undertakings were to have been required on appeal. My learned friends might be able to assist, but I'm not aware of any authority in Gibraltar of that nature. The reason I was going to advance that we would argue for the primary submission, as I put it, which is that the undertaking does not need to be received on receipt of the EAW, but it should be received before the order of surrender. The reason we say that is because Section 13 of the EAW Act, I'll go into this in more detail if necessary, but Section 13 provides a process by which the Magistrates Court can require further information before it makes an order for surrender. And it makes specific reference to the information required under Article 5. But it's very clearly framed that it is before its decision to surrender. And it says it can consider, I think the next subsection or the next section says that it can consider any information it receives at any time. But at any time, of course, before, we would say, before the order of surrender. We put that next to Article 17 of the Framework Directive, Framework Decision rather, which Article 17, as your Lordships, my lady knows, is about time limits, but it uses this key phrase of the decision to execute. And so we would say when you put this next to each other, the relevant date should be the order for surrender, the decision to execute the EAW. So that is why we say it should be received before. If we're wrong in that, we say it needs to be received before surrender in any event, for the reasons that we will go into. My lords, my lady, the issues on appeal, if I just carry on with my submissions as I intended, the issues on appeal are at Electronic Bundle 135, 136, and I'm giving my overview of how we would contend for these issues to be determined. There are 4 issues that we agreed between us are the issues central to this appeal. First, that whether and in what circumstances the return condition as defined in Section 8A of the Act is to be made in the case of a resident facing execution of an EAW. So we will say that the return condition is mandatory in the case of a resident facing execution of an EAW. The second issue is whether the return condition had to be provided in this case before the order of surrender was made by the Magistrates Court, and your Lordships have preempted a lot of, yes, I would say, on that point. So we would say yes for the reasons I've given. And indeed, even the heading itself of Section 8A of the Act, when I take your lordships to it, you will see that it says prior to execution. So again, it's a question of interpreting. We would say it's one of the two versions that we advance. Prior to execution can mean prior to the decision to execute, or prior to the actual surrender. Thirdly, whether a return condition should be made in the case of a person acquiring residence after voluntarily absenting himself from proceedings in the issuing state. We will argue that the answer to that question is that it should be, because the learned judge below, I suppose, erred, for want of a better expression. She erred in focusing on the issue that Mr. Katic was, in her view, fleeing from justice. We would say extradition is par excellence about dealing with people who are fleeing from justice. That is clear from the framework decision in its recitals. It's about dealing with people fleeing from justice. It's about creating this kind of common area of freedom of recognition of judicial decisions, but it is a balanced framework, which first of all is about recognition of judicial decisions to deal with people fleeing from justice, but it also retains that recognition of proportionality, recognition of human rights, and so on. And built into that is the issue of rehabilitation and social reintegration of the particular person. So that's all relevant. But in terms of this, we say the court below got it wrong in that sense, because to use the phrase that Lord Bingham used in Gando Armas, which is a case in the bundle, and I'll take your lordships of the board, my lady, to it later. It is clear that the extradition is all about dealing with fugitives. And then the fourth issue is whether the surrender order made against the appellant should be quashed and the appellant released from custody. Well, we would say the answer to that should be yes, because for two reasons. First of all, because the way Section 45 stands, if we're right in our grounds of appeal, in our submissions, then there can only be one outcome, which is if the appeal is allowed, there has to be a discharge. There is no other leeway. And secondly, and also importantly, we have reached the point now that the board should be entitled to consider issues of proportionality, which perhaps was not the case in the courts below, but as the time has gone on and he has now reached beyond the two-thirds point, it is right that the board, considering the balance intended by the framework decision and indeed the EAW Act, which balances recognition, acting against people fleeing from justice, making sure that people are penalized for offenses, but balanced against issues like proportionality, making sure people aren't held in detention for longer than they need to be to serve their time. Balanced against all that, there should, we would argue, it is right that the board should consider the issue of proportionality in the outcome, and therefore it should be reflected. And this is why I said at the outcome of my submissions, at the outset of my submissions rather, that the board could consider exercising the power under Section 33A of the Act, which in our view would allow the court to order that the appellant serve his sentence in Gibraltar. My lords, my lady, those are my submissions in overview, as it were. I'm going to turn to the detail of that. First, dealing with some of the facts, but I'm going to do this in very broad outline because of my Lord President's indication that the board is familiar with the facts and the papers. So the record is is I'll just give the board some references. The warrant itself is at electronic bundle 4, and there, without engaging too much time on this, your lordships, my lady, will see that this was a 10-year sentence. It was 11 originally. It was reduced on appeal. There are. I'm not going to read passages of it to the board because.
Just looking at the opening words on page 5.
Yes.
It's been issued by a competent judicial authority. I request the person mentioned below be arrested and surrendered for the purpose of conducting a criminal prosecution or executing a custodial sentence or detention order. So is one of the things that's common ground that this is a warrant falling within the IB case, that this is to be treated as both a warrant for prosecution and a warrant for sentence?
Yes, my lady, there is common ground. There's no issue between us. There were issues in the courts below, but those have been resolved, and we accept, I think we both accept, that this is an IB type of case. Under Croatian law, he's got the right to seek a retrial because of the technical finding of in absentia. We'll take it further than that, and that is where we are. I don't think I need to take the board to any great detail of EAW itself, other than perhaps just to draw the board's attention to the paragraph at the bottom of electronic bundle 6, which is 3.4. Which is about the person not being personally served with the decision. The person will be personally served with the decision without delay after the surrender, and when served with a decision, the person will be expressly informed of his or her right to a retrial, in which he or she has the right to participate, and which allows the merits of the case, including fresh evidence, to be re-examined, and which may lead to the original decision being reversed. And the person will be informed of the time frame within which she has to request a retrial.
I think you mentioned a moment ago there'd been an appeal against sentence, and the sentence had been reduced by a year.
Yes.
But the fact that he's appealed against the sentence doesn't stop him then going back and having a retrial.
That's correct, under Croatian law. Yes, yeah. That is correct.
Seems quite surprising, but there it is.
My lord, yes. Well, I'm not going to make any submissions on that point. That, as we understand it, and it is common ground, and the papers suggest that that is clear Croatian.
Well, I can see it's common ground.
So, my lords, my lady, then just to highlight perhaps the Magistrates Court order was made on the 3rd of February, which is at electronic bundle 40. The judgment itself of the Magistrates Court is at 38 of electronic bundle. And there you will see that, and this is I think the point that my lady was raising just a few minutes ago at electronic bundle 38, because in the Magistrates Courts, the magistrate had considered that the EAW did not apply to, that the 8A did not apply to Mr. Katic because of the difference between the prosecution, the intended prosecution point, and the serving of the sentence. So that's what the Magistrate Court believed. When by the time the matter reached, I didn't appear in the courts below, the Magistrate Court or the Supreme Court, so I can't assist on the specific submissions made. But by the time the case had reached the Supreme Court, it was common ground on the basis of the case of IB that it did apply. But then the issue changed into the Supreme Court holding that there was no need for a guarantee. There is further information received from Croatia, again, I'm just going to give you the reference and draw your Lordship's attention to it, but not intending to pause in my submissions to read any part of this, but so that your Lordships and my lady has the reference. There is a letter sent by Croatia to the government law officers, which is at electronic bundle 47. And the thrust of this letter is to provide information about the process in Croatia, but it emerges from this letter that it is clear that he has the right under Croatian law to seek a retrial.
I've misheard your page number.
Sorry, my lord?
I think I've misheard your page number.
Sorry, my lord. It's the letter starts at electronic bundle 46.
Ah.
Sorry, I think I said
Right.
45. Yes.
Well, the letter doesn't really matter, does it? Because they, in the arrest warrant, they take the box which says that he has that right within a year, and we can't go behind that anyway.
Yes, my lord. I'm just offering it to the board in terms of greater information on the facts. What we would also point out to, which is maybe relevant in terms of proportionality, if I may, is the reference at electronic bundle 51, where it's clear that under Croatian law, in this, just reading from the final paragraph of that letter, that after execution of half of the custodial sentence to which he was convicted, Katic has the right to request conditional release from the court. So that's the position under Croatian law. The guarantee itself is at electronic bundle 53, and it was received. It's undated, but we know it was received on the date of the Interpol flash was received, which is at electronic bundle 54. So we know that it was received on the 26th of March by the government law officers in Gibraltar. So we take it from then. That was before the appeal was determined by the Supreme Court, but after the order of surrender by the Magistrates Court. The guarantee itself accepts that Mr. Katic should be returned to Gibraltar in order to serve the custodial sentence or detention order passed against him in the issuing member state. But it also says at the end that if the wanted person, Mr. Katic, doesn't want to use the legal remedy of the annulment of a final judgment and take part in the new proceeding, we can act according to Framework Decision 909. Now, Your Lord, the board will be aware that Framework Decision 909 is, to some extent, if I can put it this way, the other side of the coin to the extradition request. So you can seek someone's extradition on the basis that there should be a judicial, a freedom of recognition of judicial decisions in different countries, of orders that people should be extradited to stand trial or to serve a sentence. Framework Decision 909 provides a common area for the recognition of and enforcement of custodial sentences awarded by other states in the state in which you are resident. So what Croatia is saying in this guarantee, it's saying two things. First of all, we are prepared to give the condition, the 8A3 condition, now that we know that he's a resident. But if he doesn't want to appeal and he accepts the sentence, then we are prepared to use 909. 909 is, as I say, about the serving of the sentence in Gibraltar. So we say that brings into play, again, the Section 33A of the Act, to which I will turn just a bit later in my submissions.
So if he seeks a retrial, the sentence is repealed, so he could get a different sentence on a retrial. Is that right?
It would be a matter of Croatian law,
Yeah.
my lord, as to
That's the implication, isn't it?
what the ambit is. I'm assuming that under Croatian law, you can either seek to entirely clear your name and have the whole thing either retried and a different outcome, or that you can only appeal the sentence, or you can, after taking advice, decide to do neither. My lord, I'm going to...
Under Framework Decision 989, if you have a sentence in one country, but you're serving it in a different country, whose laws apply to when you're let out, at half-time or two-thirds or whatever? What conditions?
It's the law of the country in which you are serving your sentence. and that's clear too, and I'll take your lordship to that.
Just so I'm clear, you interpret this as meaning that whether or not he exercises his right to a retrial, any further sentence will be served in Gibraltar?
Yes, that is how we interpret it.
Right.
I'm not sure if that's not clear on its face. Certainly we're not taking any point that Croatia have given a half-hearted...
I mean, we can act rather than we will act is a slightly odd way of putting it, but as long as you're satisfied,
yes, well,
that's what it means.
My lord,
I'm not going to pursue it further.
I'm not sure if it's a sort of lost in translation, but we're not taking the point that Croatia's given a sort of ambivalent guarantee. In fact, what we say is Croatia's given an option to Mr. Katic. Yeah. They've said, come back to Croatia on the basis that we are prepared to meet the guarantee required by Gibraltar law. So if you get nowhere, you'll serve your sentence in Gibraltar, or we give you the option. If you want to forego your right of appeal, you can serve your sentence in Gibraltar, but accept your 10-year sentence. Now, his position now is that.
Yeah.
But if under 909, the Gibraltar court has to engage in a discretionary exercise, in other words, to determine whether or not it wishes to have him back, isn't that right?
Well, under Section 33A,
yeah.
it would absolutely have to do that, yes.
Whereas, so that if you've got somebody who's convicted of a heinous crime and hasn't got much association with the executing state, there would be a discretionary decision to be made if you're simply looking at the sentence. But if you're looking at somebody charged with exactly the same crime who is subsequently convicted in the executing state, you say the law is that there's no discretion for the issuing state to decide whether or not it wants him back.
Well, not in terms of 8A3, no.
No,
so we say there's no discretion on 8A3.
There's a distinction there between there's a distinction there between somebody who's got a final decision made, as it were, the issuing state has a discretion, but if there has to be a further finding, then as far as that is concerned, you have to have you remove all discretion.
Well, but the reason for that, we would say, my lord, is that when we get into the framework decision is because Section 8A3 of our Act is the way that Gibraltar has decided to apply Article 5.3. Section 33A is the way that Gibraltar has decided to apply Article 4.6 of the directive.
I understand that, but what's the policy issue that would suggest that the court should have discretion in relation to a sentence that has been determined, but that it wouldn't have any discretion at all in relation to somebody convicted of exactly the same crime and hit with exactly the same sentence? What is the policy argument for that difference of approach?
Well, my lord, I'm not sure I can advance a policy argument in terms of the rationale of why the legislature, or indeed the government, the minister who introduced the 2014 regulations in which some of this is placed, what the policy argument would be, but it is what we would say is that it is clear that that is the effect of Section 8A3.
And do you accept that the Framework Directive, the 2002 and 2009 directives, in fact give a discretion in both cases?
No, my lord, we don't accept that. So, well, discretion. In fact, let me moderate my submission, if I may. As your lordship knows, the framework decision is binding on the outcome, but gives us scope on methodology and form. Article 4.6 is very clear on its terms. It's about giving the judicial authority discretion.
Yeah.
Article 5.3 is not about that. It's giving the discretion to the member state. It's a discretion to decide whether or not they want to amend their law to introduce a regime that gives that subjects extradition to that condition. They are different discretions. It's not a discretion to the court. The state.
That's how you're going to distinguish the case relied on by your opponents.
Yes, the state, and it can do one of a number of things. It can decide to subject the extradition to a condition of a mandatory nature, which is what we say the state has done here, which is not dissimilar to how Holland has done it in the case of SF, because in the case of SF, which is in the bundle, it's clear what the Dutch law is, and the Dutch law is, we would say, in our submission, mandatory in nature as well. And there is no difference, and no point was taken in that case, albeit I accept that that case doesn't turn on whether or not it is mandatory. But we would say they are different discretions. The Article 5 discretion, created by framework decision, is a discretion for the state. The state has decided to make it mandatory, and the choice of form is for the state. And there's nothing wrong with it. It aligns with conforming interpretation, and there's no contradiction, and hence why we say X is irrelevant, in a nutshell. So, my lady, I'm just passing on quickly to conforming interpretation, but in view of what I've said so far, I would say that we can do this fairly quickly, because I'll just give you a few references, but the case of Pupino, of course, is well known to the court. It's at 481 of...
Just on conforming interpretation, yes. There is a slight oddity in that Section 8A3, which deals with the return condition, does not appear to limit it to cases where the warrant is a warrant for prosecution. I mean, it doesn't make any difference in this case, given that it's accepted this is a warrant for prosecution. But just as a matter of tidying up, do you accept that the conforming interpretation would mean that you would have to insert that requirement that the return condition can only be insisted upon by the executing state where the warrant is a warrant for prosecution?
Well, of course, a warrant for prosecution means one for the serving of a custodial sentence too, under the case of IB. So,
yes.
Subject to that, yes, my lady.
Right.
But there's certainly a link, and I'm going to take the board to it, but the link being between the execution of a 8A1, the link between the execution of an European arrest warrant under 8A1, and then subject to the conditions in 8A3. I'm going to take the board to that. I don't propose to say much on conforming interpretation, because I have already, in some respects, said it. What we will say, in essence, in our submission on conforming interpretation, that it is, of course, it's for the court to consider whether there's been a result which is contrary to that envisaged by the framework, but we would say that on proper scrutiny there is no infringement of that principle, and that the Section 8A3 conforms precisely with with Article 553. So I will say that. I had a number of references to Assange and French and Portugal, but unless the board wants me to, I'm not going to make those submissions because I believe we're now in common ground on the conforming interpretation. So I don't propose to do that. I will say that it is relevant in the interpretational exercise. Cases like Gando Armas, of course, which is electronic bundle 437, and the references speech of Lord Hope in Dabas, which is electronic bundle 414. Those references, we would say, are relevant. And also, I'll give you the reference of electronic bundle 446. I will perhaps.
Sorry, so what's relevant?
What is 446?
So let me just pull them up, if I may. So your lordships, my lady has the submissions with greater clarity, if I may. If we can start with Gando Armas, which is at 437. So I'll take you to that, if I may, and then I'll take you to the other one, because this case is relevant in different ways. We would say, first, because of the point that the court below made in relation to fugitive offences, so fugitive offenders. So at 443, Lord Bingham, there, just a sort of powerful line, we would say that it is not unusual, at 2 of the judgment, it is not unusual for those facing prosecution or imprisonment in one country to take refuge in another in the hope of evading trial or punishment as the case may be. So this is what we say is the extradition is par excellence about fugitives. Nothing surprising about that. The other relevant quotes, if I may, at 446, so at paragraph 8, we would rely on that, and what is said there, that the interpretation of the framework decision must be approached on the twin assumptions that Parliament did not intend the provisions of Part 1 to be inconsistent with the framework decision, and that while Parliament might properly provide for a greater measure of cooperation by the United Kingdom and the decision it did not intend to provide for less. Of course, we accept that. But also at Lord Hope at 24, when he says at electronic bundle 452, paragraph 24, where he sets out his view that extradition treaties need to be read generously, but, as he says there, but the liberty of the subject at sea is at stake here, and generosity must be balanced against the rights of the persons who are sought to be removed under these proceedings. And then at the bottom, but the task has to be approached on the assumption that where there are differences, these were regarded by Parliament as a necessary protection against an unlawful infringement of the right to liberty. So rely on those passages. My lords, my lady, the opt-in documents are in the electronic bundle. Again, I don't propose to take the board to the opt-in documents because we accept where matters lie. I proposed next to jump straight into the framework decision and take the board to just some salient points there, if I may. So the the framework decision, the board will find at 302. So just from 303 onwards, if I can just go through it and pull out things which we say are particularly relevant. So recital 1 makes clear, electronic bundle 303, that this is about persons who are fleeing from justice. So that's recital 1, as the pure objective of this. So of course it's about fugitives. So it was wrong for the court below to say that there's some kind of distinction to be made between fugitives and other people. Then, of course, the objective is at paragraph 5, which is about the free movement of judicial decisions. That's also a fundamental objective of that. But there is also a principle of proportionality that I would rely on, which is at recital 7. So it's about not going beyond what is necessary to achieve the objective. And of course, the constitutional rules and the and fundamental rights are, of course, not infringed by this framework decision. There is a clear balance to be struck when implementing that. So states within that doctrine of conforming interpretation can ensure that due process is followed, that principles of proportionality are followed, that principles that people are punished for their crimes but not kept beyond the time that they should be kept in custody is all part and parcel of the balancing exercise, we would say. So extradition is, of course, a two-stage process, arrest and surrender. So that's Article 1. And then just taking the board to Articles 4 and 5, which are at the heart of this. So 307, Article 4. We say the opening words are hugely important, which say the executing judicial authority may refuse to execute the European Arrest Warrant, and then 1 to 7. So pausing there, this gives a discretion to the judicial authority. It is a discretion not to execute an arrest warrant on one of these bases. So it's optional, as the title says, it's optional non-execution. That power is vested in the judicial authority, not in the state, vested in the judicial authority. Under 6, Article 4.6, if the European arrest warrant has been issued for the purposes of execution of a custodial sentence or detention order where the requested person is staying in or is a national or a resident of the executing member state, and that state undertakes to execute the sentence or detention order in accordance with its domestic law. So the discretion there on the judicial authority, which is reflected in our legislation, and when I take you to the legislation, I'll show the board where. But that clear discretion that way. Article 5, which is at Electronic Bundle 309, is headed guarantees to be given by the issuing member state in particular cases. And it says the opening words, again, are important and provide the distinction. The execution of the European arrest warrant by the executing judicial authority may, by the law of the executing member state, be subject to the following conditions. Again, I pause there. May by the law of the executing state. So that discretion is on the state first to decide what its law should be, whether or not it should amend its law to introduce a condition. It can decide not to. It can decide to do so. It can decide to do so for some people and not to others, because if we go to Article 5.3, which is just further down the page, the condition is where a person who is the subject of a European arrest warrant for the purposes of prosecution by is a national or resident of the executing member state, surrender may be subject to the condition that the person, after being heard, is returned to the executing member state in order to serve there the custodial sentence or detention order passed against him in the issuing member state. Now, national or resident, and the option to the state to decide whether to amend its law to introduce that condition. The state can decide not to do it at all. The state can decide to impose a condition in respect of nationals or residents. The state can decide, as a middle ground, to impose a condition only in relation to its nationals. It can decide to do it in respect of some of its residents and not others. What we will say is that Gibraltar has chosen to impose the condition in respect of all its nationals, all its residents, without qualification. It was a matter for the state in the legislation to decide how to do it. The choice of the form and method was for the state, and it chose. And that's the form. That's what we say. Then, if I may just point out two further articles that might assist. So, Article 15 sets out some. Article 15 is about surrender decisions, but it sets out that the judicial authority shall decide. That's an electronic bundle, electronic bundle 312. The executing judicial authority shall decide within the time limits and under the conditions defined in the framework decision whether the person is to be surrendered, because there are some very clear and relatively tight time limits. If the time limits are passed, then the person is discharged. We're not arguing anything on that. But the time limits are there. That is the objective of the framework decision. It's entitled to provide those proportional protections for people also. And it says, if the executing judicial authority finds the information communicated by the issuing member state to be insufficient to allow it to decide on surrender, it shall request that the necessary supplementary information, in particular, with respect to Articles 3 to 5 and Article 8, be furnished as a matter of urgency, and may fix a new time for the receipt thereof, taking into account the need to observe the time limits set in Article 17. And I'll take your Lordships and my Lady to how that is reflected in our legislation, but that provides a mechanism, of course, that if a case comes before the Magistrates Court, and it's a case of a resident, and it's a foreigner, and it's obvious that there should be perhaps a guarantee, that cross-reference to Article 5, for example, provides the court an ability to adjourn the case so that it doesn't make its decision, subject to the time limits, of course, but to allow the receipt of information under Article 5. So Article 17, which is electronic bundle 313, again very clearly sets out some time limits. And the time limits are not relevant to our case, but what I would say is that clearly on the face of it, there are some set restrictions to how this works in terms of procedure and time limits. But what is, we would say, relevant in the context of when the guarantee should have been received is the heading to Article 17, the time limits and procedures for the decision to execute the European Arrest Warrant. So the time limits and procedures for the decision to execute the European Arrest Warrant. So when we put that next to Article 15, which allows further information to be requested, taking into account the need to observe the time limits set in Article 17, which are about time limits and procedures for the decision to execute. The decision to execute is the decision to the order for surrender. So that is why we say that informational requirement pointed to by Article 15 is up to the order of surrender. The order of surrender was on the 3rd of February 2020. Could have been adjourned, could have been sought. In fact, the Magistrates Court thought it was not relevant for the reasons in the judgment. Then, of course, if
your case is the magistrate went wrong by making the surrender order without the guarantee. You say there can be an appeal, but it's too late by then to have the guarantee because the only powers of the appellate court are to allow or dismiss the appeal. So you say they have to allow the appeal. But what happens to the arrest warrant then? Does it still continue in effect, or is it somehow negated by the process that's happened, or is it still extant and capable of execution?
Well, of course, it's always open to the issuing state to issue a fresh European arrest warrant and provide the guarantee. I mean, this could easily have been done in this case. But to answer your ladyship's question also in this way, the Magistrates Court decided it wasn't, the whole issue of Section 8A was not relevant. The guarantee was provided later. Given the submissions I've made earlier, I didn't appear at the Supreme Court. If I had appeared at the Supreme Court, I would have made the same submissions as now. In other words, that the court probably would have been able to take account of the guarantee received, despite it was received after, for the reasons that I advanced earlier. There are potentially two ways that the guarantee can be considered. First, that it's before the order for surrender, but secondly, also it could be that it can be interpreted on the basis of the guarantee being received before the actual surrender, but after the order, subject to a clear condition being put into it.
Yes, but there was no condition put in the magistrate's order. So given where we were, which is that the magistrate, wrongly you say, thought that there was no need for the guarantee, therefore did not require the guarantee, therefore also, of course, did not make it conditional on there being it being received before surrender. But given those facts, as I understood it, you then say that when the matter got to the Supreme Court, the only courses open to the Supreme Court are to allow or dismiss, and if they allow, to discharge the arrestee. And what I understand you're saying is, and what would then have to happen would be to start afresh with a new warrant.
Yes, I mean, that it could be cured that way, and relatively easily, we would have thought. He would still have been in Gibraltar. Preparatory steps could have been taken, I suppose, for there to be a fresh European arrest warrant on the ready, just in case it was necessary to discharge him. There have been other cases where, certainly in the past, not of European arrest warrants, but where that I've been involved in, where there have been arrest warrants discharged, but then there's been a fresh arrest warrant on different basis, curing issues. Sorry, my lady, does that answer the question?
Yes, it does.
Thank you. So I was going to then also just highlight briefly Article 23, which sets out the time limits for the surrender of the person. Again, time limits are relevant in providing proportional protection, because if the time limits are expired, then of course, under 5, Article 23(5), upon expiry of the time limit, the person is still being held in custody, he shall be released. So even though there has been an order for surrender, if he's still in custody by the time you get to the time limit, then that you are mandated to be released. And then the answer to the partial answer to the question asked by my lord before, and the rest of the answer will be in the Act, but But if I just point to Article 26, which is that the issuing member state shall deduct all periods of detention arising from the execution of the European arrest warrant from the total period of detention. So he was to be served in the issuing member state as a result of a custodial sentence or detention being passed. So you see the read across there that the custodial periods of detention served by the appellant here are relevant. And of course, Article 33.2, which at Electronic Bundle 320, which applies this to Gibraltar. I'm going to take the board to the Act itself now, if I may, which is at Electronic Bundle 185. And the Act, and this is the Act in, this is the Act in its form as it applies to Mr. Katic's case. That Act has been amended now because of our exit from the European Union. But this is the form that applies to Mr. Katic. So your Lordships, my lady, sees that the relevant again at section 6, electronic bundle, page 191. Again, it's about arrest and surrender. That's the process for extradition, as the board knows. So I take you straight to 8A1, which is at 195 of the electronic bundle. And the board sees there that at 8A1, the execution of a European arrest warrant transmitted in accordance with Section 8 is subject to the conditions in subsections 2 and 3. 2 is irrelevant to us, so it's mandatory. It is subject to the conditions. And then 3, where the person named in the European arrest warrant is a Gibraltarian, as defined in Section 4 of the Gibraltarian Status Act, or resident, and he is to be surrendered to the issuing state, he must, after being heard, be returned to Gibraltar in order to serve a custodial sentence or detention order passed against him in the issuing state. So, again, I make the point, this is the way that the state in Gibraltar has opted to exercise its discretion to amend its law in conformity with the framework decision. That amendment which is at 8A1, which I've just read to the board, and 8A3 was added in 2014. That's clear from, I'll just give you the reference, but I'm not going to turn it up. I'll give you the reference that it's clear that it's added in 2014. The regulations and the relevant parts of it are at electronic bundle 265-266. So that's where the board will find the source of it, which is a ministerial, it's under cover they were in regulations under cover of the authority of the Minister for Justice. Those amendments were made.
Can I ask you just about 8A? It's clear from 8A2 that must is mandatory. In other words, it's inconceivable really that somebody would be sent back if those conditions were not satisfied. Looking at 8A3, where the same must is used, even on a conforming interpretation, must be interpreted to mean that there was an element of discretion. In 8A3, when it clearly couldn't in 8A2.
So what we would say no to that. We would say that it means what it says. It's clear on its terms what it says. The state has made that option and it's chosen that form and method. And
so this would be contra legem to interpret it in that way, you say?
Yes.
What is a bit unsatisfactory is it doesn't actually provide a mechanism for making it effective as such. I mean, just saying in your own law that the other country will send somebody back doesn't put any obligation on them to do so.
Well, the obligation would be on if you receive a guarantee.
I know, but there's no provision for that here. It's just that you have to read in effectively, or to.
Well, we would say it's clear that, taken as a whole, and given the provisions of Article 5.3, when we put this side by side, and taking into account that it's headed guarantees from the issuing state prior to execution, that the intention is very clear, and that it is about receiving a guarantee from Croatia prior to execution. The discussion can be about whether execution means the order for surrender or actual surrender. But we would say the mandatory nature of it is clear, and as my Lord says, it would be, we would say, also contra legem to read it in a different way. And that within the scope of the penal, of course. So.
And you say there's nothing in the framework decision that prevents the member state making that choice to make it a mandatory requirement?
Yes, my lady. Indeed, we would say that it is absolutely the intention of the framework. It is absolutely the objective mapped out by the framework decision. The objective in Article 4 is to allow a discretion to the judicial authority. The objective in Article 5 is to allow a discretion to the state to amend its law to subject it to conditions, because they are different things. Because Article 4 is about optional non-execution of the surrender. Article 5 is not about optional non-execution of the surrender. Article 5 is about optional conditioning of the surrender. It's not about not executing it. It is about executing it on terms.
Is it possible to construe Article 5.3 as meaning that the state can provide an option for the issuing judicial or for the executing judicial authority to decline to return on that basis? The use of the word may in Article 5.3 might, on a certain interpretation, suggest that.
Well, my Lord, I suppose it could be said that in conferring a discretion to the member state to amend its law, the objective extends to conferring it so that the state can decide whether to make it mandatory or discretionary. But we would still say it would be up to the state, and that if the state were to choose a mandatory route, it would not conflict with the conforming interpretation doctrine. That's what we would say. So, and then Section 9, which is Electronic Bundle 196, subject to Section 8A, the central authority shall, as soon as may be after it receives a European Arrest Warrant transmitted to it in accordance with Section 8, take the necessary steps to ensure its execution. So, again, the execution subject to Section 8A. Then, moving on, the relevant section which needs to be read with...
And it's clear that what's being executed is not the surrender order, but the warrant itself.
Yes.
Yeah.
And the relevant section to be read with Section 8A in this case is Section 12, which is at 202. Section 12 governs the procedure where a person refuses to be surrendered.
Yes, I mean, it has to be brought before the court first under Section 10. I mean, does...
Yes.
And then he either consents or opposes. Yes.
Yes, my lady. He is brought before the court. He consents or doesn't consent. If he consents, it's Section 11. If he doesn't consent, it's Section 12. This case is a Section 12 case. So So looking at section 12, you see that at electronic bundle 202, where a person does not consent to surrender to the issuing state, the Magistrates Court may, after hearing that person, make an order directing that person that the person be surrendered to such other person as is duly authorized by the issuing state. And subsection 1 is then, under subsection 2, subject to the following provisions. That is to say, under A, the European arrest warrant transmitted in accordance with Section 8, and where appropriate, such undertakings or statements as are required under this Act as are provided to the court. And under D, the European arrest warrant transmitted in accordance with Section 8 has been executed in accordance with the provisions of this Act. So putting those two together, if I may, the effect of it is that it requires the undertakings to be made. If any undertakings are required, it requires that undertakings are made before a person can be surrendered, before an order for surrender can be made.
Before a person can be surrendered, or before the order is made?
Before the order is made, sorry, my lady. Yes, thank you.
I thought you accepted that it could come after the order if the order provided for it.
That's my secondary submission, my lord. So I'm riding both horses, if I may.
Well, I was looking at paragraph 33 of your written case, which
yes.
submits that there are two alternatives.
Yes, I accept those two alternatives, not accepted by the court below. No. And as I say, no cross appeal against that finding. But to the extent that it is relevant for the board, obviously, I ride those alternative submissions. So then, my lords, my lady, I take you to 13, which is, the reason I take you to 13 is because of the reference I made earlier to Article 15 of the Framework Decision. So 13 is where, in proceedings, electronic bundle 204, in proceedings to which the Act applies, the Magistrates Court is of opinion that the information provided is not sufficient. It may require the issuing member state to provide it with such additional documentation or information as necessary, in particular with respect to Articles 3 to 5 and Article 8 of the Framework Decision. So as a matter of urgency and within such period as it may specify, taking account of the time limit. So again, same point. So Article 15 talks about the time limits in Article 17. This talks about the time limits which are relevant, which are present in other parts of the Act, but they are similar time limits. It's the same concept. Your ability to seek information before you make the order for surrender, having regard to the time limits. And under 13A, as I said earlier, the Magistrates Court may at any time make use of additional information received from the issuing state relating to a previous request pursuant to a European arrest warrant transmitted in accordance with Section 8. So what we would say is that taking all of those provisions in the round, this is our primary submission. This is why we say the guarantee needs to be received before the order for surrender. Having regard to the time limits, having regard to the process, the Magistrates Court has ability to adjourn, seek information before it makes a decision to execute the arrest warrant, decision to order the surrender. Then, as I've mentioned it a lot, and my lords, my lady, can I take you to electronic bundle 234? Which is 33A, which I have mentioned on occasion. And so a person so this is an exception to a duty to surrender. A person shall not be surrendered under the Act if the European arrest warrant has been issued for the purpose of the execution of a custodial sentence or detention, and the person named in the EAW is a Gibraltarian or a resident of Gibraltar or staying in Gibraltar, and the court makes an order requiring the person to serve the period of the sentence in accordance with the law of Gibraltar. Now, the submission was first made at the Magistrates Court for those who appeared for Mr. Katic at the time, that the magistrate should make an order under 33A. The magistrate at that time declined to do so for the reasons he gave in his judgment. 33A was not relied on in the Supreme Court, but in our submission, 33A swings back into relevance, if I may put it this way, because of the passage of time and the fact that Mr. Katic has now served more than 2/3 of his sentence. So that the court, and the court is not defined there, and certainly our submission is that as the court is not defined, and the Privy Council has obviously the powers it has under the appeal part of the statute, which we will turn to in a few minutes, but it also has the power under section 33A to make this order if it so considers it is proportionate to do so, given the indication that I have made as to Mr. Katic's position. Again,
you say the Supreme Court could have made this order and we could make this order?
Yes. Plainly, the Supreme Court, given the judgment of the court below, would not have made it, because of its findings in respect of the fugitive nature of Mr. Katic and so on. It would have been doubtful if the court would have made that order. It wasn't asked to make that order, but we say the court has power. And that is a continuing power, so we would say. But you've got a discretion. This is a discretion. This is a discretion on the court. Both, again, I make the point.
And making that order now, I mean, on your submission, as I understand it, would amount to, its substance, a direction for unconditional release.
Yes.
Because the law of Gibraltar would so provide.
Yes.
Yeah.
Yes. But it would not be different, my lord, it would not be different to Mr. Katic returning to Croatia, deciding not to appeal, or losing an appeal, and getting the same sentence, coming back, and then be released.
Save a couple of air flights.
Sorry?
Save a couple of flights.
Well, in today's world, he might not get there. But yes. Yes.
But also the process would take time, presumably.
Yes.
During which time he'd be in custody.
Yeah.
Yes, and on a more serious level, apart from my joke on the flights, proportionality, because one of the threads running through the framework decision, and I'm going to take you to a couple of authorities here in a minute, is about social reintegration of an offender, making sure that he does not spend in custody longer than he needs to be to serve his time, penalizing people, but penalizing them in a way that they serve the time that they have been given and not over-serve time. So we would say it would be proportionate for that outcome to be reached. I make a final point on 33A that again, this comes from the 2014 regulations. So your lordships, my lady, will find that. Not going to ask you to turn it up, but if you want the reference so that you know where the source of this came, it's electronic bundle 289, and you will see that it comes from the 2014 regulation. The powers on the appeal are this court's powers on the appeal are at electronic bundle 241. So,
just looking at all these provisions about what the very complex provisions about what the Supreme Court can and can't do, and it can the powers it has. detention pending conclusion of an appeal. Under 42, does that derive from the framework decision or a European source, or is that something that has just been provided for in the domestic legislation?
Well, certainly I haven't seen it in the framework. What happens usually when Gibraltar legislates is that sometimes they use English precedents, but I'm not sure, I could not say whether such a complex set of arrangements are present anywhere else.
Well, it's very similar to the English Extradition Act.
I'm grateful. They are certainly complex, I accept them, and full of different tiers and sub-tiers. And indeed, you see that when it comes to these, the powers of this court. So they start at Electronic Bundle 241, which is the ability to appeal, and at 242, Section 45, is what happens if an appeal is allowed or dismissed. So where we are, we are in the territory of an appeal under Section 44 by the person in respect of whom the European arrest warrant was issued. So 44(2)A, so we're in that territory. So you can allow or dismiss the appeal. And then in subsection 45(2), subsection 3 applies if the person in respect of whom the European arrest warrant was issued brings an appeal under Section 44, and the Privy Council allows the appeal. So if, in respect of Mr. Katic bringing the appeal, this case, and it were the Privy Council to allow the appeal, then the powers are, we would say, restricted to the powers in subsection 3, which are to order the person's discharge or quash the order for his surrender. If the appeal was against the decision of the Supreme Court to dismiss an appeal under Section 38, again, our situation. There are powers.
I think the sort of cases that I had, and possibly Sir Declan Morgan had in mind, and I won't speak for him, where undertakings have been required on appeal. May be cases where a magistrate orders the discharge and the prosecution appeal, and then the appeal may be allowed on, or the terms may be imposed. Well, because that can happen. That's covered by these rules.
Yes,
isn't it?
yes, my lord. If this had been an appeal by Croatia,
yes,
that would be possible, because if your lordship was to look at subsections 6, 7, and 8 and read them together, your lordship will see that at the end of that process, so where this is an appeal in effect by Croatia, were it to have been that, you can quash the order, remit the case to the Magistrates Court, and direct the court to proceed as it would have been required to do if it had decided the relevant question differently at the surrender hearing. So that is possible were this to be an appeal by Croatia.
So suppose the magistrate would say, right, well, there's no guarantee from Croatia here, so I'm going to order his discharge. The Croatia then appeals to the Supreme Court. At that point, Croatia provides the guarantee. The Supreme Court could then have, as it were, cured the position.
Yes.
By making it some direction under here.
Yes.
But you say it doesn't operate the other way around.
It doesn't operate the other way around, certainly at this level. It's plain from...
I think below as well. It's similar
yes.
in the Supreme Court.
Yes.
So it does... Sorry. No.
I'm so sorry, you go first.
It does mean that if the magistrate makes an error of fact or law, then on your case, that's it. If there is that error, the Supreme Court must allow the appeal and discharge the person, and subject to detaining him under
Well, they'd have to.
42 that the issuing authority then has to say it attends to appeal. But how can it appeal if there was an error of law by the magistrate? It may be that the magistrate, as you say happened here, goes rather awry, and that may be accepted by the issuing authority. But according to you, your interpretation, there's one chance to get it right before the magistrate, or for the magistrate to get it right. If he or she doesn't, then you slide down the snake and have to start again.
Yes, my lady, but what I would suggest is that one has to take a step back and understand, I suppose, where this came from, which is that before there was no common area for the recognition of judicial decisions. Extradition was much more complicated before. The purpose of this was to layer out a common framework of recognition of judicial decisions, but balanced with proportional and protections in respect of due process. Because if I have time, and I hope to, take you to one of the cases that says similar language, but it was about, there was no guarantee, I suppose, put it that way, that when you map out such a framework across so many states, that there won't be specific procedural protections in every single country. So this was about having, yes, an open door policy, but about an open door policy that was subject to very clear time limits and very clear procedural protections, because the liberty of the individual was also relevant, and it was a balancing exercise. So what we would say to that is that, yes, that is the effect of these sections, but it is intended, and it is intended right through the heart of the legislation, because it's left to the state to ensure whether these mechanisms, these procedural processes should be what they are. Now, they are, I accept, I recognize entirely. They give much more leeway to the appellant, or the person to be surrendered, than the state. Ultimately, it is probably for a reason, that he is the person who is being sought in a foreign country.
Mr. Appellant, I thought a few minutes ago you were suggesting that we could make an order under Section 33A,
Yes.
that he serve his sentence in Gibraltar, and
Yes.
therefore there be no surrender, which would in fact have the effect that he'd be released. But how can we do that within the straitjacket imposed on the board by Section 45 when he's the appellant?
So my lord, it would be for the courts to determine it in our submission in this way. You'd say that insofar as the appeal, you can allow it or dismiss it. So if you were to allow it, well, clearly he would be discharged. If you were to dismiss it, not in your lordship's and your ladyship's minds, but I'm not sure what's going through, but if you were to dismiss it, I would say side by side with that, it would be proportionate to make an order under 33A, because 33A is what we would say is a standalone provision.
Yes, but if the order which is appealed in this case is the second surrender order imposed by the Supreme Court, I mean, you appeal orders, you don't appeal judgments, and we dismiss the appeal against that order stands. I don't see how we can then go on and say, actually, we're going to set that order aside and substitute a service in Gibraltar provision. I can understand your submission that could say, well, you could allow the appeal with the effect he has to be discharged and no injustice or disproportionality would be caused, because but for the lack of power to do so, you could have made an order under Section 33A, but so could the Supreme Court and so could the Magistrates Court. And you would thereby, by allowing the appeal and ordering his discharge, achieve the same substantive result.
Yes.
It's just about understand that.
Yes.
We couldn't actually do it, could we?
Well, I see the distinction that your lordship makes, and I hang on to it tightly because, and I put it forward because Well, Your Lordship says, could we do it? We would say that Your Lordships and my lady may decide that that is an outcome that serves justice, because...
Oh, yes, well, that's my second... I can quite see how just allowing the appeal with the consequence that he's released could be sort of, as it were, justified in one's mind by thinking that any of the courts below could have achieved the same result under Section 33A. Now, but not at the time they were doing it.
Yes.
Yes.
So, well, I'm going to leave the Act. I'm not going to take you to the regulations. All I would say about the regulations, and I only make this point in case my learned friend intends to take a contrary view, but what we would say in relation to the 2014 regulations, which is the source of Sections 8A, part of Section 12, and Section 33A, is that we would say the intention of the minister is clear and unimpeachable. And I don't think that my learned friends suggest otherwise. And the 2014 regulations start at Electronic Bundle 261, if the board wanted the reference. So, may I, I've got about 15 minutes, so I'm hoping to very quickly make a reference to 3 cases, 3 or 4 cases, but I think I can do it within the allotted time without infringing the time limits, now that we've been talking about time limits a lot of the morning. May I take the board to the case of IB, so IB is IB Thank you. 724.
All right, 724.
724, yes. So IB is of course, the well-known case about the construction of whether the EAW extends to the custodial sentences point.
Well, it's saying that even if what you have looks as if it's a warrant for execution of a sentence, if in fact they've ticked the box that says he's entitled to a retrial because it's treated as in absentia, then you treat it as being both, and so the return condition has to be met. Is that
yes,
ma'am? Right?
Yes, correct. But the reason I wanted to take the board to IB is not for that reason, but for the reason that the rationale of the framework decision is discussed, and the rationale being also about rehabilitation. So I wanted to take the board to that. So at Electronic Bundle 733, this is the Advocate General in IB, but at paragraph 31 at B, which is in Electronic Bundle 733, the Advocate General says this: similarly, Article 5.3 adds that a surrender may also be conditional where an arrest warrant is sought for the purposes of prosecution and the person concerned is a national or resident of the executing member state. In this situation, the condition can consist only of the issuing member state's undertaking to return the person to the executing member state in order to serve there the custodial sentence or detention order passed against him in the issuing member state. This being the case, Framework Decision 2002-584 on the one hand protects nationals or residents of the executing member state in order to preserve their connections with a particular place. This is really a form of exception to the arrest warrant based on the protection of certain emotional ties which a person has with his or her most intimate circle, furthermore assisting in any future rehabilitation. So rehabilitation relevant to that. Also at 735, again the Advocate General at 42, slightly different point, but we would say relevant, at paragraph 42 of the judgment. In the first place, it's important to emphasize that the case law, the Court of Justice, has never stated that the grounds for non-execution and conditionality in Articles 4 and 5, respectively, of the framework decision must be strictly interpreted. In fact, to the contrary, the judgment in criminal proceedings against Walsenburg is actually very clear in its reluctance to impose a particular interpretation of these provisions, even recognizing at para 61 that when implementing a provision such as Article 4, the member states have of necessity a certain margin of discretion, that thus the Court of Justice has not only avoided mentioning a strict interpretation, but also has not recognized either that the member states have a wide margin of discretion. On the contrary, they have a certain margin of discretion, but definitely not a wide margin. So I rely on that in terms of the interpretational exercise. And at 736 of the electronic bundle, at para 44, clear from the first line that, moreover, the need to interpret the framework decision in the light of fundamental rights has become more imperative since the entry into force of the Charter of Fundamental Rights, Article 7. We would say, in light of our own Charter of Rights and the Gibraltar Constitution, the framework decision needs to be also, and certainly the legislation, the European Arrest Warrant Act, needs to be read in light of and in conformity with the fundamental rights set out in our Constitution. That's the Advocate General. The court itself, court's judgment. The court's judgment starts later, but I want to take the board to page 747. 747.
Thank you.
So at 747, at 50, while the system established by Framework Decision 2002-584 is based on the principle of mutual recognition, that recognition does not, as is clear from Articles 3 to 5 of the Framework Decision, mean that there is an absolute obligation to execute the arrest warrant that has been issued. And then at 52, that is the case in particular under Articles 4, 6 and 5.3 of Framework Decision 2002-584 for both types of European arrest warrant envisaged by the Framework Decision. Those provisions have in particular the objective of enabling particular weight to be given to the possibility of increasing the requested person's chance of reintegrating into society. So that point is repeated at 58 in holding as it does in that case. Furthermore, such an interpretation is the only one which currently offers a real possibility of reintegrating into society for a person resident in the executing member state who, having been sentenced by a judgment which is not yet enforceable, may be retried in the issuing member state. That's obviously about the decision in that particular case. But I rely on it for the principle that social reintegration and rehabilitation is uppermost in the exercise. I take your lordships quickly to X, which is at X is at 511.
Sorry, page
511.
Thank you.
So X is the case relied on by my learned friends on the interpretational exercise, but what I would say on X is, first of all, it is very different to our case because of the opening words of Article 4 and the interpretation exercise is very different. So your lordships, my lady, will see that this was a case about the interpretation of Article 4.5. You see that from page 512 at the top of paragraph 1 of the judgment, you see that this is about 4.5. 4.5, if you wanted to see it placed in the judgment, is at 514, the electronic bundle, and at paragraph 7 there is a quote there as to what 4.5 is. And this is a case which decides that the use of the words may refuse in Articles 4, the opening words, means that there must be a judicial discretion. That's what it holds, and the relevant paragraphs there are at electronic bundle 519. And in particular, I would very quickly give the board the references to paragraphs 41 to 44, because I'm running slightly out of time. But I will make very strongly this point, that this is a case which, in our submission, is not relevant to the exercise that we are embarked on today, because it's about construing Article 4. Article 4, the construction of Article 4 stems from the opening words, which are clear, give the judicial authority a discretion. This is not what we are saying today under Article 5. I make that point strongly. I've made it before, so I won't repeat it. What I will say in relation to X before I leave it is that X also recognizes that the framework decision needs to be interpreted in accordance with fundamental rights, and that reference is at electronic bundle 521 and at paragraph 58. So it's left in our submission to the state to decide the form and method of that. If I can take you then finally to SF, which is a case at electronic bundle.
46 of that decision seems to be at odds with the earlier case you referred us to about the margin of discretion. Paragraph 46, the court has repeatedly held execution of the warrant constitutes the rule. Refusal to execute is intended to be an exception which must be interpreted strictly.
Yes, my lord, I accept that. I accept that. I accept that. It's at odds with what I read earlier. I accept that. But what I would say is that it doesn't affect the fundamental submission that I make, but I accept that. I just take you to SF finally, which is at 761. And the reason I want to take you to this case is because SF, again, it's not about the construction of Article 5.3. But it says two things, or at least it's clear, two things are clear from it. First of all, it's clear that the Dutch law, in equivalent of what our Section 8A3 would be, because Holland has, or the Netherlands rather, have opted to introduce a condition, it is similar in effect because, and that's at 785, electronic bundle 785. There is a citation there of the...
Sorry, the reference again?
785. And at paragraph 11 of the judgment, there is a direct quote of the Dutch law, which says the surrender of a Netherlands national may be allowed, provided that a request is made for the purposes of a criminal investigation against that person, and provided that the executing judicial authority considers that it is guaranteed that if he is given a definite custodial sentence in the issuing member state for the offences in respect of which the surrender may be authorised, he will be able to serve that sentence in the Netherlands. My only point there was simply to say, because the case does not turn on an interpretation of this particular provision, but the only case is to say that the fact that this is mandatory in Gibraltar is no different in effect to what would be the natural construction of that, which appears on the face of it to be entirely mandatory also. But I also wanted to take the board to the preceding paragraph, which is a straight quote from Article 25 of Framework Decision 909, the other side of the coin, as I put it earlier, to this framework decision. And it says this: Article 25 of that framework decision, entitled Enforcement of Sentences Following a European Arrest Warrant, provides, without prejudice to framework decision 2002-584, provisions of this framework decision shall apply, mutatis mutandis, to the effect that they are compatible with provisions under that framework decision, to enforcement of sentences in cases where a member state undertakes to enforce the sentence in cases pursuant to Articles 4.6 of that framework decision, or where, acting under Article 5.3 of that framework decision, it has imposed the condition that the person has to be returned to serve the sentence in the member state concerned, so as to avoid impunity of the person concerned. So, first of all, you see that 909 is the other side of this framework decision. Secondly, that the powers are parallel. Thirdly, we would say that when you place Article 25 next to Article 5, the it that is referred to towards the end of that sentence is the state. There's no other. So this is about the state imposing the condition under its law because it has chosen to do so, or not chosen to do so, deciding not to do so.
I'm sure you're watching the clock, Mr. Transport.
I am.
Probably time to sum up.
I am watching the clock, my lord. Absolutely. There are other cases in the bundles, and they may be referred and relied on by my learned friends, and I will reply to them if need be. There is another case which is called Wizocki. I'm just going to give you the bundle reference. It's electronic bundle 798. In particular, I'm going to rely on 798, 799, 805, 806. I'm just going to give you those references. But that is a case, in a nutshell, where one of the lower courts in the United Kingdom, in England, decided that in the context of proportionality, it was relevant, because of passage of time, to take account of whether someone should be extradited. And we would make a similar point, but in respect more strongly as to the fact that Mr. Katic would have served his sentence if he forgoes that, as indeed his instructions are to convey to the court.
This was the full sentence?
The full sentence, yes. My lord, those are, my lady, those are my submissions.
No, well, thank you very much, Mr. Transport. Now, Mr. Rocha.
My lords, my lady, grateful. I too, before the lunch break, propose to just draw a brief landscape canvas for your lordships before this afternoon dealing in some detail with the authorities. In many ways, this case is a relatively simple case. Is Section 8A of the European Arrest Warrant provisions in Gibraltar in relation to guarantees an optional or mandatory provision? Is the language to be interpreted in an optional or a mandatory manner? The appellant contends that subsection 3 of 8A is mandatory in nature. The Supreme Court, with which we agree, considered that in the circumstances of this case, subsection 3 was not mandatory, and with that, the respondent respectfully concurs. In fact, whether it's optional or mandatory is actually a bit of a misnomer, because Article 5 is almost a condition precedent section. If you look at the framework directive, you've got Article 3, which are the mandatory non-compliance grounds, and you've got Article 4, which are the optional ones. Then you've got Article 5, which is almost a condition precedent ground in relation to execution. It sits slightly outside the optional and mandatory provisions contained in Articles 3 and 4. Perhaps before I go any further, it might be useful to consider the learned judge's ruling in the Supreme Court, which is at page 77 of the electronic bundle, my lords. It is common ground that the magistrate got it wrong below. IB was not referred to in the Magistrates Court, and hence the decision of the magistrate was wrong. He was not properly addressed on Section 8A of the Act, particularly in relation to the after being heard terminology. And so the magistrate thought that the Section 8A was limited in scope to persons whose return was sought in order to stand trial. That was corrected at the Supreme Court by counsel for Croatia, and IB was drawn to attention of the courts in that regard. Again, also not in contention that Mr. Katic was resident at the time of the order, albeit we are unclear what dates exactly apply, but it is not an issue that he was a resident of Gibraltar at that time. What the learned judge did at the Supreme Court was essentially decide that, on the face of it, when dealing with a resident of Gibraltar, and I say that the timing of the guarantee, I agree with my learned friend, it is not at the time of the issuing of the warrant, it is either at the time of the order for surrender or at the time of surrender itself, subject to that being made a condition. So I agree with my learned friend in that regard.
So you accept that it's only possible for the undertaking to be effectively accepted by the Supreme Court if the magistrate's order has made it a condition that the undertaking is received before surrender.
The lady, yes.
Right, and then there can be some judicial oversight of whether the undertaking has been provided in a satisfactory manner.
Precisely.
But do you accept that in the absence of an appeal by Croatia, the Supreme Court was bound to discharge the appellant, given if because of the absence of an undertaking, if the section is mandatory?
If the section is mandatory, yes, my lord.
You do?
Yes. What the learned judge does is she considers Section 8A and drawing on the authority of Wisniewski as referred to in Paulinska Zawanda, and apologies for the pronunciation of those names, she extracted the general principle from those authorities and in essence considered that the operative provision, in considering that operative provision, she was required to carry out a contextual analysis of those provisions, and that in the interest of justice, her view was it was necessary to interpret Section 8A of the guarantee return provision in a purposive way, and she concludes at paragraph 21 of her ruling, which is at page 86. There is no doubt that Section 8A is aimed at protecting the rights of an individual who is a national or a resident of the executing state. However, entitlement to that protection becomes questionable when the residence in the executing member state has been obtained with the consequence of avoiding a term of imprisonment following a conviction in the issuing state.
Mr. Rockwell, I could just interrupt. I'm sorry for interrupting in the middle of this, but are you saying then that if an undertaking of some sort, in this case we were looking at a particular undertaking, but as a general proposition, that if there is a court-to-court undertaking which is delivered after a magistrates court hearing and is provided to the Supreme Court, that it has no bearing on the decision?
It's a question of substance over form. In effect, the guarantee was given at the time that Mr. Katic would have been surrendered. That guarantee was in place. But the powers, as my learned friend has pointed out, of the Supreme Court extend no further than dismissing or accepting appeal.
Surely if it turns out that, I mean, the question I'm really asking is, if it turns out that the guarantee now being in place, the outcome, the order was correct, albeit that the reasoning was wrong. Surely in those circumstances, then you dismiss the appeal.
That would be my second horse, yes.
Yes, but that depends upon being entitled to take into account in the Supreme Court the undertaking that had by then been provided. But I just want to be clear whether you say that no matter what the position, that any undertaking of that type in relation to a 5.3 issue or even a 4.6 issue cannot be looked at by the Supreme Court. Is that right?
Well, my Lord, no, I think it can be looked at, but that would be a second horse I would ride. And like my learned friend, I am also riding two horses. I am sticking with the rationale and the reasoning of the learned judge in the Supreme Court to say, well, actually, you know what, I'm giving it a purposive application, I don't need it. But I would also submit, and the learned judge appears to make almost a second surrender order.
Yeah. But in paragraph...
But there's no power to do that.
There's no power to do that. But actually, if you read the last paragraph of her judgment, of her ruling, it's an extempore ruling, it's at page 89, she says the appeal is dismissed and the appellant is to be surrendered by the Croatian authorities, but not before the expiration of 28 days from today. On the face of that, she appears to be making a surrender order.
Well, I know it's drawn up that way, but there's no power to do that.
There's no power to do that under the appeal provisions under Section 38.
So it has to be treated as a dismissal of the appeal.
I think that's right, and that would be my position, my Lord.
Well, paragraph 5 of the judge's judgment says that the EAW is defective in effect and cannot be cured retrospectively.
That's right.
So what I want to understand is whether, if the difficulty lies as a result of the absence of an undertaking before the Magistrates Court, can that be cured in the Supreme Court by the provision of the said undertaking?
No, my Lord. I believe it can't.
Can't they?
I believe it can't.
It would have been open to Croatia to cross appeal.
Correct.
And on the basis that seeking a different order. And that way could have been cured, but without a cross appeal, it doesn't look as though it can be.
Possibly, but then again, the powers of the Supreme Court do not appear to extend to the making of a surrender order on its own. It can either dismiss the appeal or have the appeal. It could do no more than that. So I was confused by the final paragraph of her judgment, given that she'd said at paragraph 5 that it was incurable effectively. But I'll come to that if I may, because...
The order purports to authorise any constable in Gibraltar to hand Mr Katic over to a person duly authorised by Croatia. But fortunately, nobody purported to act pursuant to that aspect of her order. Right.
And at paragraph 21, which is at page 86, she consciously refers to the appellant being a fugitive from justice. What she says is no doubt in my mind. I mean, he's foreign shopping is what she's saying. He's done a runner from Croatia. He's come to Gibraltar. So turns out that actually it's a slightly shorter sentencing period in Gibraltar than Croatia, so it would appear on the facts of it. And that he's placed himself outside the reach of the Croatian authorities. And she says, I'm not allowing him to rely on Section 8A to manipulate the law.
How does she get there as a matter of interpretation of the wording of 8A3?
Sorry,
How does she get there as a matter of interpretation of the wording?
On fugitive or...
Well, on 8A3. At all, yeah. Well, she doesn't really address that. She says the outcome.
She doesn't, the Lord, no.
Is she saying he doesn't count as a resident, or that it's not mandatory and I have a discretion which I will exercise?
The latter, because she accepts he's a resident, because we accepted he was a resident in Gibraltar at the time. Coincidentally, there's no requirement under Gibraltar law to declare convictions or sentences that are extant when you apply for residency. So there's no...
But assuming that it is discretionary, if one's prepared to make that leap with you, then the question is, well, what kind of factors should a court take into account when deciding whether to exercise the discretion to require or not require Croatia to return Mr Katic to Gibraltar if he is retried and sentenced? and she seems to regard it as relevant factor that he's a fugitive from justice. Whereas one might have thought, given the passages in the authorities to which your learned friend took us, that more relevant would be factors to do with the state of his integration in Gibraltar society, because that seems to be why one might or might not require the return condition to be satisfied. Nothing to do with whether he's a fugitive from justice. Of course he is. That's why he's being extradited.
My lady, that's right, but before her ladyship was the information in relation to him really having more ties with Croatia than Gibraltar. So I would say she would have considered that because she would have had the affidavit before her. And he has...
Does she say anywhere in her decision?
She doesn't, no.
I would have thought if there is a discretion, it'd be perfectly relevant to say he was a fugitive. There's all the difference between somebody who lived their whole life in Malta and happens to have committed a crime in Croatia, and somebody who's only come to Malta because they're on the run.
My Lord, yes.
We're not, as I understand it, here to deal with that, whether the discretion was properly exercised. I understand you to accept that if we were to conclude that Section 8 was to be read down or interpreted in accordance with Article 5.3 so as to be discretionary, then that's the end of the day, so far as you're concerned.
Exactly, no, yes.
You just want a clear decision from us whether it's mandatory or discretionary.
Precisely.
Yeah.
And in many ways, albeit not precisely the same, it's probably in many ways the exercise that the learned judge made the Supreme Court. So she would have utilised the framework decision interpreting the European Arrest Warrant. She would have looked at the margin of discretion she has in interpreting that provision in the must-may, whether it's a mandatory or optional.
But anyway, it's a question of law. So
exactly.
Her thought process is, in that respect, with respect to her, don't matter.
Yeah, well, yes.
Say so far as they help our process of thinking.
As long as the result was the right one, how she got there, my lords, we may be in a slightly different position today. I wasn't at the Supreme Court to argue it, and I would have argued it slightly differently, but hopefully the outcome would have been the same one.
But it's a fairly cold question of law, which you...
It is a very cold question of law.
I don't understand the appellant to be arguing that if he's wrong and that it is discretionary, that he's got an alternative ground that the discretion shouldn't have been exercised.
No, I don't understand that.
He's putting his case on the fact it's mandatory.
Yeah.
Yes. So essentially what we say is that when you look at the framework decision, you drawing assistance of the margin of discretion provisions and the case law and provisions concerning X, which I'll take you to later, considering the principle of conformity in Pepino, which again my learned friend grateful for that, for confirming he agrees that applies. The doctrine of statutory interpretation based on the common law, which is what I think the learned judge does, presuming that Parliament legislates give effect to its international obligations to do so in full. And drawing on that, she comes to the conclusion that Section 8A3 should be read in a purposive manner.
That would be fine, but the problem we've got is Article 5 of the Framework Directive that gives the discretion to the law of the country and not to the judicial authority.
That is correct.
That seems to be pretty difficult for you to get round.
That on the face of it is difficult for me to get round, my lords, but when we look at the authorities, what I suggest the authorities tell us is it's the rule that we comply with warrants rather than the exception. And therefore, when interpreting our national provisions, we must look at those rules and we must try our utmost to execute those warrants.
Well, I wonder if that's actually the rationale of the judge. I'm looking at paragraph 20 of the judgment at page 86.
Yes.
I mean, it appears that she interprets Article 5.3 as being discretionary.
That's right.
Now, do any of the European cases support that?
I'll take you to them, my lord, but
I just want, does any European case indicate that the 5.3 condition is discretionary? I think that's a yes.
No, not that I've come across. But there are other cases, analogous situations, where optional surrender provisions have been legislated nationally in a mandatory manner. but has allowed the national courts that margin of discretion. So even though it's mandatory, what the authority says, and this comes back to proceedings involving X, which I'll deal with in due course after lunch, what the authority says there is, even though it's a optional provision and the national provision is mandatory in wording, nonetheless, the judge must have that margin of discretion to look at the case in a contextual basis. So in the context of the case, is this a mandatory provision? And that's what X is useful for.
I can't say that at the moment because X is based on a thing that says the judicial authority must have a may, whereas we're dealing with a situation where the law may, and the law may, but it hasn't.
My Lord, yes, and it's not on point. What I'm saying is analogous to that point.
I mean, the real question is whether the double use of may means you're into a may straitjacket in terms of what the local law can do, or whether the double use of condition in the third line of Article 5.3, referring back to conditions in the opening 3 lines, actually means it's just the double use of may really doesn't make any difference. We're all looking at the same condition, and it may be subject to that condition by the local law.
That's right.
It's ultimately a very dry and dusty point of international interpretation on which there's no authority.
My Lord, yes.
But are there other provisions similar to Article 5 which would also be affected by your rule, if it were such a rule, that in enacting their domestic law, the member state must always give some discretion to the judicial authority? Because I would be concerned about how an interpretation of Article 5, which you're pressing upon us, might affect other provisions.
I think because, as I said at the outset, my lady, the Article 5 provision, the 8A provision, is slightly sits outside the mandatory and non-mandatory provisions in Article 3 and Article 4. It's a condition precedent provision, almost.
Yes, but the question is whether there's a discretion as to its imposition.
On the condition precedent, yes. Yes. And that is what we are arguing. On that condition precedent, drawing on X, what we should look at is allow judges a margin of discretion where someone like Mr. Katic has absconded, foreign shopped, become a resident to take advantage of the situation. What the judge is saying here effectively is, I have a margin of discretion to say this is a may rather than a must. And in this case, I'm not allowing him to take advantage of that provision to avoid being returned to Croatia. That is what the learned judge is saying here.
And that's probably right if the judge is right about the may.
Yes.
Because there's a case called Poplowski, I think, which makes it clear that if there is a discretionary element and the state imposes a strict test, that the state has to find a way of implementing the framework directive.
That's right.
Yep.
And she says that at paragraph 19 of her judgment, page 85. The general principle be derived from Pavlovska and applied to the present case is that where an individual intentionally absents himself from a jurisdiction so that a sentence cannot be enforced against him, he should not be able to use that absence to frustrate his return.
I think that's a slightly different proposition. I think the Poplowski case is more directly on the first issue.
This is the principle.
That's a different case.
This is the Pavlovska case.
Yes.
Yes.
Can I just run this possible approach to the construction of 5.3 past you? The opening words say the execution of an arrest warrant by the executing judicial authority may, ... by the local law, be subject to the following conditions. Now, when you get down to 3, the condition being identified is that the person after being heard is returned to the executing member state in order to serve the sentence there. And that is a condition to surrender. And as far as I can't see any clear blue water between the word surrender and the words in the opening part, execution of the warrant by the executing judicial authority. Because the police initially execute the warrant by dragging you before the judicial authority, but it's the judicial authority that decides on surrender.
Yes.
So, on that approach, rather than it being may, it is.
I can see the merit in that argument, my lord, but
Well, I'm just running it past you because obviously this is ultimately turning on quite technical point of construction.
it is a very.
Sure that you've addressed all possible ways of looking at it.
But, my lord, I hope I have in our extensive skeleton argument.
Yes.
And we, you know, as I say, we come at this from very different angles. So the common law interpretation, the margin of discretion, and propina, which we say together, is effectively what the learned judge does at the Supreme Court in Gibraltar. She draws upon all of that, albeit not explicitly, and doesn't go through that analysis in her. It is an extempore ruling at the end of the day. And so she didn't retire and draw up a considered judgment. But she draws, I think, on various principles to say, well, you know, even though it says it's a condition precedent, I am allowed to look at the context of this case. And in this circumstance, because in my view he has foreign shopped, he's a fugitive from justice, his real place is Croatia, where he has a home and family.
Well, that's all fine if it is a discretion, but
If it is discretion.
You know, she doesn't actually address, she gets to that point.
She doesn't actually.
So we need from you to know how you can make Article 5 force in effect Gibraltar to confer a discretion on the judge.
And after lunch, my lord, I hope to do that.
And I would also be interested to see after lunch how the UK has implemented this and whether the effect of our judgment, if we agreed with you, would be to indicate that the equivalent provisions here are also not conforming with the framework decision.
I'll confirm that after lunch, maybe, but I'm almost certain that it's a may in the United Kingdom equivalent provision.
I'm afraid
There isn't an equivalent.
Oh, isn't there? That's what I'd read.
That's why then you have a look and maybe find
I'll have a look. I'll have a look.
It seems to be dealt with differently.
My understanding was that there was no mandatory requirement.
I'm sorry if that spoils your lunch.
My lords, if you'd like to.
Well, if you've reached the end of your sort of peroration and are about to start a meeting, we could rise it. Give you a bit more time just to check the English position.
Yes, my lord, just one thing before we do rise for lunch. Just worth pointing out that the Section 33A arguments were not pursued at the Supreme Court by counsel. The magistrate refused to make a 33A order. And I'll take you to that after lunch, and that was not pursued at the Supreme Court. My learned friend suggested...
I think Mr. Parties did say that in terms. Yes.
My learned friend suggested that perhaps that power vests in your lordships in this court. I would beg to differ with that, having looked at... I won't trouble you on that, my lord. So it's a convenient time, I think, for me to spend my lunch looking at a couple of...
Yes, well, we'll resume only at 2 o'clock to give you 4 extra minutes to find out what the English position is. Yeah.
Take for one of...